Mr. Worthing.
My Lords, my Lady, good morning. First of all, representation. I appear with my learned friend Mr. Patrick Vincent for the appellant insurer, LV. And my learned friends Mr. Benjamin Williams, Queen's Counsel, and Ben Smiley appear for the respondent, Mrs. Cameron. And my learned friends Mr. Tim Horlock, QC, and Paul Higgins for the Intervenor Motor Insurers Bureau, MIB. Unsurprisingly, the first defendant, now known only by description, is neither present nor represented.
Yes.
There are a number of issues to deal with on this appeal, and I'll address you on the main ones. But in an agreed division of labour, consequent on your order permitting MIB to intervene, Mr. Horlock will address you on, firstly, whether it's permissible to sue an unnamed defendant in a claim for damages only, and that submission includes the limitation point. Secondly, the terms of the untraced drivers agreement and whether or not that constitutes an inferior remedy to litigation. Thirdly, the issue of fraud. And fourthly, insofar as I've not covered the ground, the scope and consequences of the decision of the Court of Appeal. Can I start by giving you the bones of our submissions? The starting point is CPR 7, which states that a party should be named, with the result that the base position is that a defendant must be named. But the use of the word should indicates that the court has a discretion to permit an unnamed defendant to be sued in certain circumstances. The majority of the Court of Appeal decided that it was appropriate to exercise the discretion in the respondent's favour because she would otherwise be deprived of what the court considered was a substantive right to look to the insurer for compensation under Section 151. Secondly, it was efficacious to her to do so, and that in those circumstances it was consistent with the overriding objective that the discretion should be exercised in her favour.
I just ask you, is it common ground that the word should imports the discretion?
Yes, I think it is.
Yes. I mean, I was slightly surprised. I'd be interested to know whether the usage of the CPR, which uses should rather than must, apparently,
well, I don't,
actually has been subject of any consideration by the courts.
Not as far as I know, but I think, my Lord, what I would say is that if the word had been shall, we wouldn't be here. That the fact that it isn't shall but is should suggests that in certain circumstances there is a discretion to permit a claimant.
That's what Sir Andrew Morritt seems to have thought.
Yes.
I just wondered whether there was any other backing for that, because I suspect the CPR use that concept quite often.
In fact, I can't think of another example in the CPR where the word should is used, but Your Lordship may be right.
Anyway, it's common ground. So
yes. We say that the test formulated and applied by the Court of Appeal was wrong and that it was too widely drawn. The respondent did not have any substantive right against the insurers until she had a judgment. And so the existence of that right could not properly form the basis from which to apply the overriding objective. The correct test, we say, is that set out in Bloomsbury, Sir Andrew Morritt, namely that the discretion will be exercised in the claimant's favour only when to fail to do so would cause her significant injustice, and to do so would cause injustice to nobody else. In other words, to trigger the exception to the normal rule under CPR 7, the circumstances of the case have to be exceptional.
Do you distinguish between cases where the defendant can be identified, but you just don't know his name, and cases where he can't even be identified?
No.
Should you?
I don't believe so, my lord, no.
Well, I think that this may be an issue of some significance. Speaking simply for myself, I have some conceptual difficulty with the idea that you can obtain a judgment against a person who you can't even identify by location or description, because the description given of him in the amendment is not really a description at all. It could apply to anybody in the world. And there may well be an important conceptual difference between a case where you know who you want to sue, but you do not know his name, and a case where you do not know who you want to sue. There may be conceptual difficulties about getting a judgment in vacuo, and difficulties about the natural justice of suing somebody who is not in a position to defend himself because he may not have any knowledge of the proceedings.
Well, my lord, the final point is a point that we pray very much in aid. We say...
But it's more than a discretion point.
My lord?
It's more than a discretion point.
Yes.
If a suggestion is made that you are entitled to sue somebody when you have no means of bringing to the attention the fact that he's been sued, that may be a reason why you shouldn't contemplate doing it, let alone do it as a matter of discretion.
Well, my lord, yes. The way in which we've seen it is to say, and indeed our case has been, that you should not exercise any discretion, assuming there's a discretion at all, in favour of this type of action in circumstances where it's impossible to serve the defendant. And it will never be possible to serve the defendant because you don't know who he is. And that is what differentiates it, we say, from the injunction cases, because as we'll see in a moment, in all of the injunction cases, the purpose of the injunction was to prevent the tortfeasor from committing whatever tort was being committed, defamation or whatever. But that would never have any practical effect until the fact of the injunction either came to the attention of the defendant or, better still, was served upon him. Well, of course, that can never happen in this situation.
Well, I raised the conceptual problem because for my part, I think that the parties should address it, even if at the moment you haven't been taking the point.
Can I think about that for a moment, my lord? Well, my lord, you may be right in the sense that if you have an unnamed but untraceable, untraceable but named defendant, you can sue them, but the issue of the discretion simply doesn't arise if they are incapable of being named or described.
What's the difference between an anonymous and an unidentified person?
Yes, of course, arguing against myself, I think what Mr. Williams might say is this person doesn't have a name, but it could only refer to one person, namely the person who was driving the car on that day and in that place. But they are anonymous in the sense that they are incapable of being named. Let me continue for the moment. In Bloomsbury and the cases which followed it, it was an important ingredient in the decision to exercise the discretion in the claimant's favour that the court was satisfied that the defendant would be served, and this is the point I was making a moment ago, or otherwise come to the attention of the defendant so that the order would be practically effective. Otherwise, it would be pointless. In a case such as this, the proceedings can never come to the tortfeasor's attention. In considering the exercise of the discretion, the Court of Appeal should not have been so dismissive of the Untraced Drivers Agreement and its relationship with the Road Traffic Act because they interlock and form the bedrock for the scheme of motor insurance in the UK. Insofar as there was a discretion, there was no proper justification for exercising it in the respondent's favour, because the respondent would suffer no or no significant prejudice in justice because she had an alternative remedy under the untraced drivers agreement. The proceedings would never come to the attention of the defendant and so would be ineffective against him, and nor could they be properly served on the insurers as an alternative means of service. Conversely, for reasons that we will develop, if the discretion was exercised in the victim's favour in a case such as this, then the insurer would suffer prejudice. Finally, in determining whether the discretion should be exercised in her favour, the terms of the directive and the CJU authorities on which the respondent relies do not assist her for a number of reasons. Firstly, the terms of CPR 7 and the question of whether a discretion should be exercised in the respondent's favour are matters relating to the liability of the tortfeasor, not the liability of the insurer, and are governed by national law. Secondly, the respondent's Article 18 rights have not been infringed because the UK has properly implemented Article 18 in the 2002 regulations. Alternatively, even if it hasn't, neither Section 151 nor the regulations can be the subject of mar-leasing reinterpretation, because to do so would go against the grain of the legislation. And finally, nor can the discretion under CPR 7 be used to create a direct right of action against the insurer, because the exercise of the discretion does not in fact create a direct right of action against the insurer. It only enables the respondent to obtain a judgment against the defendant tortfeasor. So, my Lord, those are the bones of our submissions. You know, I think, that both I and Mr. Williams wish to raise new points in this appeal. In my case, it's a new point on service. In his case, it's the European point. The new point I wish to raise on service involves, to some extent, resiling from a concession I made in the Court of Appeal to the effect that it's normal practice to order alternative service on insurers if the driver is known but untraceable in the sense that he's disappeared.
That point has been that's been denied by the interveners, as I understand it.
It is, yes.
Yes.
They say it was a concession that shouldn't have been made. And, my Lord, I agree. The concession was based on the fact that in circumstances where the defendant is identified but is proving difficult to find, insurers will frequently agree to alternative service upon them, because that saves the cost of the claimant having to employ inquiry agents or to go by some other expensive method of alternative service. And of course, in cases, the vast majority of cases, where the insurers are acting as contractual insurers under the terms of the policy, they're entitled to do that as a contractual right. But my concession failed properly to reflect the fact that service on the insurer does not in fact constitute proper service on the defendant. It's not a form of service that can be forced on the insurer, and the cases which are said to show the settled practice, Murphy and Asbridge and Gertner and Circuit, and Abbey National and Frost, are all pre-CPR cases, and the CPR in this area has changed the landscape. My error, and I accept it was an error, was to fail to focus on the importance of service, or the fact that the impossibility of ever effecting any form of service on an unnamed defendant was a reason not to permit an unnamed person to be sued by description only. Lord, I've discussed the matter with Mr. Williams. He maintains that there is a settled practice based upon the authorities to which he refers, but he's indicated that he would not stand in the way of me arguing the point.
Well, the court has discussed this, and we're of the view that we should make a decision which has been arrived at in the light of all the legal arguments which can properly be put. And as currently advised, it doesn't appear to us that there's any prejudice liable to result from allowing these points to be argued, which couldn't be addressed, if need be, in the way in which we deal with costs at a later stage.
I respectfully agree, Mulder. Thank you. And presumably the same applies in relation to the European point raised by Mr. Williams,
right,
in respect to which I take exactly the same position. Well, can I start with the power to make the order? If the starting point is that the party should be named, then the question is whether the discretion that he should not be, does not have to be named, should be exercised. And the starting point for this is the decision of Mr. Justice Laddie in Bloomsbury. Can I ask you to look at it? It's in the Authorities, Volume 1, Tab 15, at MS 1123. This is the Harry Potter case. Just before publication, various copies were stolen, and they were being hawked around newspapers to see if they were interested in buying them in order to, no doubt, publish extracts from them. Can I ask you to look at the bottom of 1122, paragraph 20, where Mr. Justice Laddie, to whom this matter went for an urgent injunction, is looking at the principles. It seems to me, ignoring the question of balance of convenience, there are at least 4 factors which need to be addressed before a court can grant an injunction at an interlocutory stage. First, the claimant needs to demonstrate he's a good arguable case. The stronger the order, no doubt the stronger the case should be. Second, the order has to be in terms which clearly state that the defendant must and must not do. Third, it must be possible to identify the defendant against whom the order is sought. Fourth, it will only be effective against a person who, when made aware of the terms of the order, will understand that it applies to him. There's no problem here with the first 2 of those requirements. On the material present on this application, the claimants have a very strong case and the relief sought is clear. The problems, if they exist, relate to the 3rd and 4th factors. These overlap. And then at paragraph 23, he talks about if the claimants managed to serve the order here on the vendor, he would know that it applied to him. And then in 25, nevertheless, for the reason that I've indicated, I do not think it is outside the court's power to grant injunctive relief against parties who are not identified by name, but who are known to exist, who will not be in any doubt that the order is directed at them. Furthermore, if such an order is made, it seems to me it will be effective once brought to the attention not only of the person or persons directly offering their stolen volume for the sale, but also those who, knowing of the order, assist in attempts to sell it. Now, my lady, what I say we get from that is that the fact that the order is capable of being served, or at the very least brought to the attention of the tortfeasor, is an important factor in the consideration of whether or not the order will be granted at all. The matter then came back before the Vice-Chancellor, Sir Andrew Morritt, and if you turn on to 2 pages to 1125, this is Bloomsbury Publishing 2003 One Weeklies, Sir Andrew Morritt. At MS 1127, paragraph 4 of the judgment, things have moved on since the decision of Mr. Justice Laddie. The application against the first defendant, the newspaper, had been disposed of on the basis of certain undertakings. The third to sixth defendants were arrested. They were joined as defendants by name and submitted to orders. And then the question was whether the injunction should be continued against the person or persons who'd offered the publishers of The Sun the copies of the book. Sir Andrew Morritt then went through the old pre-CPR authorities, which had concluded that it was impossible to serve an unnamed defendant. And then at paragraph 16 to 19 on page 1132, he concluded that matters had changed since the CPR and the use of the word should. At paragraph 20, about just below letter B, in this case there is the question of whether he or she has been properly described. Second, the objection in that case that the order sought would not bind anyone to do or abstain from doing anything. That is not so in this case. A person falling within the description of the defendant could be liable for contempt of court if he acted inconsistently with it. Any other person who, knowing of the order, assists in its breach or nullifies the purpose of a trial may also be liable for contempt. Under 21, accordingly, I conclude in the second sentence that the claimants are entitled to join as defendants, and I'm entitled, if I see fit, to make the order sought against the persons described as quoted in paragraph 4. And then just above letter F, the crucial point, as it seems to me, is that the description used must be sufficiently certain as to identify both those who are included and those who are not. If that test is satisfied, then it does not seem to me to matter that the description may apply to no one or to no more than one person, or to more than one person, nor that there is no further element of subsequent identification, whether by service or otherwise. I pause there to say that the point about service, I think, is it doesn't matter if you can't identify the person at the point of service, but it does matter that you are able to serve him. And then the final sentence, which we rely on, I can see no injustice to anyone if I make an order in the form sought, but considerable potential for injustice to the claimants if I do not. For these reasons, I will make the order. So it's plain, we say, that Sir Andrew Morritt was making it clear that the exercise of the discretion or the exercise of a power to sue a person purely by description would only be exercised in circumstances where to fail to exercise it would cause injustice to the claimant, but the exercise of it would cause injustice to nobody else. And the nobody else in the context of our case is not just the unnamed defendant, but it's also the insurer. We say that Bloomsbury illustrates two particular points. The injunction was granted against unnamed defendants because their actual names were not particularly important. What was important was that any particular person might know from the description that the injunction applied to him or her, and that if it came to the attention of a person fitting that description, otherwise by service or otherwise, then they would be bound by it.
This was in reality an injunction against the newspapers. That was the reality of it.
Well, yes, it had that effect. But it was continued against those who were trying to sell the books to the newspapers for the purpose of finding out who they were. My lords, my lady, the relevance of service has been followed in a variety of cases in this jurisdiction, notably the defamation cases of Brett Wilson and Smith and Lycacare. I'm not going to take you to those cases, but in each of them, it was an essential feature of the exercise of the discretion to allow the injunction, that the injunction would come to the attention of the wrongdoer. In Brett Wilson, Mr. Justice Warby was satisfied that the defendant had actually been served, and the reference for that is MS 1137. The judge concluded...
Paragraph?
It's paragraph 11. He said the relevant procedural safeguards must, of course, be applied. A difficulty that can arise in cases of this kind is that of ensuring that the unknown defendants have been duly served with the proceedings, with any application for interim or final relief. Kerner provides an illustration of some of the difficulties. In the present case, however, the claimant applied on the 28th of July. The claim form was issued for permission pursuant to CPR 615 to serve the claim form, particulars of claim, any other statement of case, application notice and documents in these proceedings by an alternative method, namely by email to the two addresses mentioned above. Master MacLeod allowed that application to be made without service on the defendants and granted permission. As submitted by the claimant, the email addresses are given as contact addresses by anonymous speech. It's reasonable to infer that they are genuine addresses. The email sent to them will be brought to the attention of the domain owners. So, my Lord, Mr. Justice Warby was satisfied that the defendants had been served, even although their names were unknown, and it was on that basis that he entered judgment in default and went on to assess damages. Similarly, in Smith and Lycacare and the Canadian case of Manson and John Doe, the judges granted injunctions and awarded damages, but only because they were satisfied that the proceedings had been served. Can I ask you to look at, finally, on this topic, CMOC, which is in the... Can you give me
the... where do I find this?
You'll find this in the First Authorities bundle at tab 22, MS 1234.
You accept that all these authorities were correctly decided? Do you?
Yes. We only have part of the judgment in CMOC because it's very, very long. This was an email compromise fraud where the fraudsters hacked into the claimant's email system and sent false instructions to its bank to make large transfers to the fraudsters. The judge granted a worldwide freezing order, which was served on a number of banks and identified individuals. But there were a group of individuals, D1, who were identified as persons unknown and were never identified. Mr. Williams relies on this case in two respects. Firstly, because he says it illustrates that notification of the defendant is not a prerequisite of the order. And secondly, because he says that the judge stated that such injunctions can be used as a springboard to ancillary claims against third parties. And I think by analogy he will say that is the same as the springboard against the Section 151 insurer in this case. Can I ask you to look first of all at paragraph 2?
Which flag? Which flag?
22.
22. Page 1234.
We're still on CMSC, okay.
1234.
The first defendant is a generic group of defendants whose identity is unknown. The second to 31st defendants are named individuals. Then I would invite you to look at paragraph 15 because it's an important point in the case. Another feature of this case which follows on is that in my judgment this litigation brought by CMOC has been marked by scrupulous attention to detail and to the requirements of the very many applicable procedural rules and rigorous observance of the obligations of material disclosure on the many without notice applications on the part of solicitors and counsel involved for the claimant, and the obligations of fair presentation otherwise, to which I've referred. There have been no shortcuts taken and no glossing over any problematic points. We had difficulty in understanding from the judgment the basis upon which the trial had proceeded against the unnamed defendants. So we've been in touch with counsel for CMOC who's provided us with the draft final order, which my learned friends have seen. We've not been able to find the sealed order, but we're told that this is in the same form as the draft. We can provide copies to the court if necessary, but it may not be necessary to do so. The order contains recitals which state that the court made findings that each defendant was properly served with the claim form. That includes the unidentified defendants, and was also notified of the date of the trial. On that basis, the judge tried the case and awarded damages against all the defendants. And my lords, my lady, it's plain that the trial only proceeded against the unnamed defendants, as well as the named defendants, because the judge was satisfied that they'd been properly served.
He's saying that they've got a draft of the order.
Yes, we've got to see it.
We've got to see it. The submission's been made.
Yes. I think it would be helpful for us to see the draft order if we're going to hear submissions about the order. Can I just mention, while we have this interruption, Mr. Worthington, that I appreciate you've been taken by surprise by Lord Sumption's questions as to whether there may be a more fundamental problem here, and it's not simply a matter of discretion. I appreciate you're on your feet and aren't really in a position to think about this at the same time as addressing us. It may be that Mr. Williams might be better placed to make submissions on the point. But in that case, you would have to finish in time to enable him to add that,
Yes.
what he was planning to say in any event.
Yes, thank you. Lords, this is the draft final order. What I particularly draw your attention to is the third recital, and upon the court finding that each and every one of the defendants was properly served with a claim form, identifying them as a defendant in these proceedings, and upon the court finding that each and every one of the defendants was properly notified of the date on which this trial was scheduled.
Where do we find this?
The recitals on page
In the
one.
recitals on the second page, my lord.
Mine begins on page 10.
I'm sorry.
Right. Yes, thank you.
Your intelligence doesn't go so far as to say how people whose identity, both the perpetrators and the actual recipients of the funds, was unknown.
Well, no, but I think we can get an idea by going to MS 1242, part of the judgment, where the judge explains some rather novel methods of service. At paragraph 190, Facebook Messenger and WhatsApp Messenger platforms and service by access to data rooms. We infer from this, and this isn't covered in the judgment, we infer that although the identity of the unknown defendants was not known, it was known how they could be contacted, in the sense that there were Facebook or WhatsApp ways of contacting them, or data rooms to which they were known to have access. And it may be that they were traced via bank accounts as well, although not named. So on the basis of the fact that they had been served, the judge proceeded to enter judgment against them. And we see that from paragraphs 3 and 4 of the order. And that judgment, jointly and severally, was against the unknown defendants as well as the known defendants. The importance of that, my lord, is it's the only case that we were able to find in which judgment was entered against an unnamed defendant for damages only. And therefore that raises the question as to whether it is ever permissible to enter judgment for damages only against persons unknown. Our position on that is that that's not necessarily something which you have to determine today, but what is important is that judgment for damages cannot be entered unless the defendant, named or unnamed, has been served, and that is a critical factor. And that is what differentiates it from what the claimant seeks to do in this case, because the unnamed defendant in this case can never be served.
The implication of recitals 3 and 4 is that every one of the defendants, although their names were not known, had been given a fair opportunity to defend the proceedings.
Exactly.
Why does it matter that it's a claim for damages only rather than for an injunction?
The question of whether you can bring a claim for damages only against an unnamed person has never been determined before, save in this case. All the other cases, with the exception
I
of Seymour.
understand that, but you're saying that there's some important distinction.
Well, Mr. Horlock's going to argue that you cannot bring a claim for damages only against an unnamed defendant. I say we don't have to go that far, but what I do say, and here I entirely agree with him, is that you cannot bring a claim for damages only against a defendant if there's no possibility of ever serving him.
The difference of principle is presumably that many, perhaps most, injunctions are specifically enforceable. For example, if you've got 50 people occupying a building, you can enforce the injunction, although you don't know who they are. You know they are the individuals in the building, but you can't name them. I mean, isn't the difference? Doesn't the difference lie in the possibility of specific enforcement of not all but quite a few injunctions, whereas you can't specifically enforce a purely monetary claim against nobody in particular?
Lord, yes. I think that's right. The majority of the Court of Appeal based their decision principally on the overriding objective. We accept that the overriding objective is important, but it's only one ingredient. It seems also that the majority put a gloss on the application of the overriding objective by accepting the claimant's formulation that the test for the exercise of the discretion was whether it was necessary and efficacious to the claimant to permit proceedings against unnamed parties. And I won't take you to it, but we see that particularly in the judgment of Lord Justice Lloyd Jones, as he then was, at paragraphs 75 and 79. We say that that's not the correct test, and that the correct test is to be found in the wording of CPR 7 and the formulation of the approach indicated by Sir Andrew Morritt in Bloomsbury. Since CPR 7 says that the parties should be named, the application of the overriding objective must start from the premise that there has to be some very good reason to depart from the rule. Otherwise, the application of the overriding objective has no base from which to start. And with great respect to the Court of Appeal, they didn't do that. They didn't tie their application of the overriding objective to CPR 7. They tied it to what they believed was the claimant's substantive rights under Section 151. And we say that since it is an exception to CPR 7, then exceptional circumstances have to be present before any discretion, assuming there is a discretion, can be exercised in the claimant's favour. The respondent's case is that where there is insurance in relation to a vehicle, the provisions of Section 151 entitle her to a judgment which will be satisfied by the insurer, irrespective of whether the tortfeasor can be identified. It's an essential feature of that argument, and the Court of Appeal accepted that the respondent had a substantive right to look to the insurer to satisfy a judgment, and that the inability to sue the tortfeasor deprived her of that right. And that you will find that in the judgment of Lady Justice Gloucester at paragraph 56, it's MS 437 in CV2. We submit that that is wrong. The substantive right under Section 151 does not arise until the respondent has a judgment. The fact that the normal rules of procedure mean that she cannot get a judgment does not mean that she's been deprived of that right.
Yes, at the time when Section 151 was enacted, CPR didn't exist.
Correct.
So the Bloomsbury discretion, if that it be, didn't exist.
No, it didn't.
And therefore, the gateway of the judgment leading to a substantive claim against the insurer didn't exist.
It didn't, no.
Do we have CPR 7 in the authorities bundles?
Yes, I believe we do.
I can't find it. It's probably somewhere obvious, but I can't.
It's set out in the cases, my lord, but I don't think it's actually in the bundle.
Yes, it's in the cases. You'll find it, my lord, in our case, MS page 314, paragraph 18.
If it assists, since my learned friend was also taking you to the judgment of the Court of Appeal, there's quite a thorough exposition of all the CPR provisions in that judgment.
Yes, there is.
It's just where it's convenient you'll find it. But that begins at page 422 of the 2 appendix.
Thank you. Yes, it's paragraph 17 of the judgment of Lady Justice Gloucester at Core Volume 2, MS page 422.
Thank you.
So, my lords, my lady, we say that contrary to the approach adopted by Lady Justice Gloucester, the claimant did not have a substantive right to a judgment against the unnamed defendant. The right only arose when if the court was prepared to exercise its discretion to disapply the normal requirement under CPR 7, and only then, when she had a judgment, would the insurer be obliged to satisfy it under Section 151? And we ask rhetorically, why should a claimant who sues a defendant hoping to get a judgment which can be satisfied under Section 151 be in a better position than any other claimant in relation to CPR 7? The existence of the Section 151 remedy doesn't demand any CPR shortcuts.
Can I ask if just looking at what that CPR provision set out on page 422, the discretion is said to flow from the word should. What's made of CPR 16? The claim form must be headed with the full name of each party.
CPR 16 is in a different context, my lord. The context of CPR 16 is statement of claim. Yes, CPR 16 is applicable in relation to statements of case where the name of the defendant is known.
I think it's a little difficult for us to assess these provisions of the CPR without actually having the actual extracts from the CPR. Apart from anything else, there is often relevant commentary, but one needs to look at the whole of linguistic context of the rule.
My lord, I take the point.
Speaking for myself, I think that to say that something should be done is a slightly odd way of saying that it may not be done, depending on the discretion of the court.
Well, that is the way we've taken it to mean it.
Well, I understand that, but it's rather questionable whether we should adopt that. I mean, I only raise it as a question, but I think simply to take as common ground something like this, especially in the context of an obligation, must be headed with the title of the proceedings, and then the following words appear to be saying what it means to talk about the title of the proceedings. It means something with the full name of each party.
Well, my lord, I will arrange for you to be provided with these particular provisions. All of the ones. In particular, the ones referred to both in the statements, in the cases, and also in the judgment of the Court of Appeal.
While we're on extra statute, I was trying to find the statute provision which refers to the MIB, because the Motor Insurance Bureau is acknowledged in the statute. And I think it comes from section 95.
Correct.
Which tells you that an authorised insurer is someone who is a member of the MIB, and that's brought in against 145. But I don't think we've got section 95 in the paper.
No, we haven't.
It's not mentioned by Lady Justice Gloucester, so it'd be useful to have that then, because you were saying that the MIB is a sort of bedrock of the system, and one worth seeing where that comes from.
Yes, but, my lord, you're absolutely right. It's section 95 and 145. The important factor is that only authorised insurers can write motor business in the UK. And if you're to be an authorised insurer, you have to be a member of MIB by virtue of the legislation.
When did that reference, the MIB, first come into the legislation?
I don't know for certain. MIB, as the uninsured drivers agreement, has been in existence since 1946.
I understand. Well, anyways, perhaps someone can tell us later when it first comes into the statutory scheme.
Just going back to 4.1, paragraph 4.1, it's in the practice direction, isn't it? And if you look at it in context, 4.2 is, these are sort of practical considerations that are contained in these paragraphs. 4.2 is where there's more than one claimant, etc. The parties should be described in the title as follows: 1, A, B, 2, C, D. It's really practical stuff.
Yes, it is, my lady.
And that's 4.2, of which we've been looking at 4.1 with a view to saying this is a rule that you have to name the...
Yes, I'm sorry, I don't quite get the point.
The point is that this is a very practical part. It's the practice direction. You're wanting to elevate this to say defendants have to be named except in exceptional circumstances. Take that from the word should.
Yes.
But the whole 4.1, 4.2, they're practical considerations of how to run litigation rather than going to the substance of what you're doing.
But the two in this instance go together. If the base rule is that you should name a defendant, then that's what you should do unless there's some exceptional reason, whether it's a practical consideration or not, with respect.
I'm struggling with the procedure and the substance of things. You've all formulated it in terms of there is a discretion, should we be entitled to have the benefit of it.
Yeah.
Whereas I think maybe I see it slightly more radically, or might do.
I'm also puzzled at the moment as how a practice direction could alter the substantive law, which predated the CPR.
That was based on the procedure practice.
Well,
No, the
yes,
rule
it
of court,
was.
wasn't it?
That was based upon the preceding rules of the Supreme Court. But the question of whether and to what extent a party has to be named is a matter of procedural law.
Well, so you say.
Yes, I mean, this was what I was raising right at the start, but that the assumption made by Sir Andrew Morritt was what you've all been treating as common ground. I think we may need to think about that. And it would be more helpful to do so when we've actually got the relevant provisions of the CPR in front of us.
Yes.
It may well be the boundary between substantive law and procedural law in England differs from that which the Lord Reading the Chair and I are used to in Scotland, where I know from other involvements that they're not the same.
Well, in answer to your lordship, I'm not aware of any substantive law which bears on the issue of whether a party has to be named. And I believe in the research that we've done for the purposes of this case that if there was such authority, we would probably have found it. Mm-hmm. And I've certainly seen this as a question of procedure, of civil procedure.
There are some procedural rules which reflect such a basic legal policy that they frankly amount to rules of law. There's a difference between a procedural rule that says you must serve such and such a document within 14 days and procedural rules that deal with fundamental questions like who you have rights against, which is normally a question of substantive law. I mean, a judgment is an independent source of legal right. So there must be, at least arguably, some person against whom this right is exercised. Mm-hmm.
And is raised judicata only as between the parties to the case, whoever they may be.
Yes. It probably comes back to the point that Lord Sumption put to me earlier on, and whether a person sued by description is truly a person at all, in effect.
Mm-hmm. Well, it depends on the description. If he's the person for the time being located at number 5 railway cuttings, that's one thing, because you can go there. But if he is a person who some years ago was at the wheel of a car at a particular moment, that's a different matter.
Well, I agree, my lord. And we may have got to, I say this respectfully, we may have got to that result by what you may decide is the wrong route. The route we've got to that conclusion is by saying you can't serve this defendant. And if you can't serve him, then you shouldn't be able to sue him. Now, that may be the right or the wrong way of putting it, but that's the way we've seen it.
Well, it may be symptomatic of a more fundamental principle.
Yes, it might.
But I mean, if one looks at the sort of cases which are cited in the Bloomsbury case, including the sort of Fry and Barnett case, which established the previous rule that you had to name the person, they trace it all back to the sort of Judicatory Acts and before.
Yes.
And so it's seen that the rules are really an embodiment of a principle which has been based in the legislation since. And it would certainly be surprising if the CPR had sort of got rid of that idea altogether. The common ground seems to be that it's relaxed it to the extent that there's a discretion, but you say the general approach remains as it was in the previous cases.
Yes, I'm about to say, well, otherwise one struggles, to be frank, with the use of the word should. It must be there for a purpose. And the answer may be the way in which it's been exploited in the injunction cases, because if the word was shall, then cases such as Bloomsbury and those which have followed might have had to find their source of being able to come into existence by another route. But that doesn't apply in a case, and this is the fundamental point of our submission, if you simply can't find and therefore can't sue, can't serve the defendant, or at least bring the injunction to his attention.
Am I right in understanding the word should appears in the practice direction and not in the rule itself? Because that's what we're looking at on page 422, the practice direction.
I'm sorry, my lord, that we didn't provide you with all this. It didn't occur to me that
We thought it was common ground.
I don't think it appears at all in the rule.
It's the practice direction law.
It's only in the practice direction.
Well, it's the practice direction law.
Yes, because it derives from the rules.
I mean, there's certainly authority on what the practice direction status is. I don't know what it says, but that was something which
Well, it is a source of procedural law, but a practice direction can't alter the substantive law, so that if the problem is that you can't have a right which is exercisable against nobody in particular, then it's hard to see that the practice direction can change that, whatever it says.
I respectfully agree. Can I continue with
Yes,
my
of course. Yes.
submission as I was developing?
Yes, I'm sorry, we'll try to restrain
that's...
our interventions and let you make your submissions.
The approach adopted by Lady Justice Gloucester, we say, doesn't apply Sir Andrew Morritt's criteria, despite the fact that his reasoning was expressly adopted by the Court of Appeal. On Lady Justice Gloucester's formulation, namely, that the respondent had been deprived of a substantive right, there was little, if any, room for any discretion. The way in which the case was effectively put was the claimant has a substantive right, which she's entitled to have vindicated, and therefore the discretion effectively must be exercised in her favour. But we say that's not the correct test. The question is whether a failure to exercise the discretion will cause significant injustice to the claimant or injustice to anyone else.
That's paragraph 22 of Sir Andrew Morritt. You say that's the key test.
That's the test.
Yes.
If, subject to the conversation we've been having the last few moments, there's any discretion at all in these circumstances, then that is the correct test. And, my lords, the majority of the Court of Appeal, because they were determined that the respondent had a substantive right, allowed that to colour their attitude to the application of the overriding objective and the existence of the alternative remedy. Our case is that the respondent suffered no prejudice, or no prejudice of any moment, if she could not sue the unnamed defendant, because she had a perfectly adequate alternative remedy against the MIB under the Untraced Drivers Agreement. But the consequence of the way in which the Court of Appeal addressed the issue was that they were entirely dismissive of the relevance of that alternative remedy because they considered it was irrelevant against the background of the failure to allow her to vindicate her substantive right. And my lords, that is important because the question of whether a claimant should be assisted to obtain a judgment against an unnamed defendant in circumstances such as this case involves a holistic consideration of the entire scheme for compensating the victims of road traffic accidents in the UK. My lords, and this point will become important in another guise in a moment. It must be remembered that contrary to the way in which motor insurance works in most of Europe, in the UK, insurers do not normally provide blanket cover for vehicles. The UK insurance model is to insure specific people to drive specific vehicles for specific purposes. And as Sir Ross Cranston pointed out, it's paragraph 112 of his judgment at MS 452, the fact that it's the driver-user rather than the vehicle that is insured indicates that the identity of the driver is important within the framework of the Road Traffic Act. It's important for another reason. Although the insurer is obliged to satisfy a judgment under Section 151, the legislature has given it a right of recourse against the uninsured tortfeasor under Section 1518. If the insurer is obliged to pay the judgment because the vehicle driver is uninsured, it can claim the money back from him. Now, plainly, it cannot do that in a situation in which the driver is unidentified, and that is prejudicial. Section 151 can't be looked at in isolation. It must be considered alongside the Untraced Drivers Agreement. The government entered into the Untraced Drivers Agreement in order to provide compensation for the victims of untraced drivers. So the scheme extends both to vehicles which are untraced, but also to cases such as this, where the vehicle is traced and may be insured, but the driver cannot be identified. And the importance of this, when one is looking at this holistically, we submit, it can be indicated by a short passage I'd remind you of in the judgment of Sir Ross Cranston at Core Volume 1, MS 452. Sorry, my lord. Core Volume 2, I beg your pardon. Paragraph 118, it's 453, I beg your pardon. He said this: there is also the greater potential for fraud if proceedings can be taken against unnamed drivers without MIB investigation. Mr. Horlock will deal with this. As well, there is the threat of undermining the balance between the statutory and MIB avenues for claimants to obtain redress following motor vehicle accident. That balance in the existing arrangements may not be ideal. In other countries, compulsory insurance is of the vehicle and is comprehensive in nature, but the arrangements in this jurisdiction are long-standing and have parliamentary approval. In this difficult field for policymakers, it's not for the court to disturb these arrangements through sanctioning an exercise of discretion where there is no injustice to remedy. And Lord, that's fairly powerful, and yet the majority of the Court of Appeal, frankly, seem to consider that the alternative remedy under the UTDA was effectively irrelevant. And, my lords, the Court of Appeal dismissal of the alternative remedy under the untraced driver agreement, indeed the relevance of any involvement of MIB, it was a matter which they ignored, despite having cited to them the case of Sahin, which had expressly stated that the RTA could not be considered in isolation from the MIB agreements. That's in the Authorities Bundle 2 at tab 28. MS 1333. In Sahin, the claimant's vehicle was damaged by a hire car. The car had been hired to D1, who was insured to drive it, but he let someone else drive, but that person was not insured. That person, as in this case, was never identified. The claimant obtained a judgment against D1 on the basis of what's called the Monk and Warby principle, namely that he'd caused or permitted the driver to drive uninsured in breach of statutory duty. The claimant then sought to enforce the judgment against the hire car insurers under Section 151, and the issue was whether allowing someone to drive uninsured was use of the vehicle within the meaning of Section 145 of the Act, so as to render the insurer liable under Section 151. Can I invite you to look at in the judgment of Lord Justice Longmore, at paragraphs 20 and 21. In paragraph 20, he concluded that permitting the use of a vehicle was not use. And then he records Mr. Engelman's submission that in 21 that Section 145 should be construed to mean that use included permission to use by reference to the directives. And he recites the directives. And then in paragraph 22, he refers to the judgment of Lord Justice Ward in Bristol Alliance, and in paragraphs 22 and 23, and then Lord Justice Longmore goes on to say, in the light of that judgment, in these circumstances, there is, in my judgment, no scope for construing Section 145 in isolation from MIB arrangements, so as to accord precisely with the Second Motor Directive, since the aims and spirit of the directive are complied with, and there can be no suggestion the United Kingdom has failed to implement the directive. Mr. Engelman's argument is therefore misplaced. And then he goes on to record a separate argument in 26 that Mar leasing principles should be applied. In 27, he says, all this is quite unnecessary when the MIB untraced driver agreement covers the situation satisfactorily. The only respects in which it can be and slightly was suggested to be unsatisfactory are, and then he sets out the same arguments as in this case. But these are considerations which cannot influence the true construction of either the 1988 Act or the terms of the policy insurance. They are in any event expressly contemplated in the preamble to the second directive. So, my Lord, the Court of Appeals, the manner in which the Court of Appeal treated the alternative remedy under the Untraced Drivers Agreement was, with respect, wrong. It was a real alternative remedy which had a purpose. And it's to be compared when one is looking at the issue of comparative prejudice to the prejudice which would be suffered by an insurer in these circumstances. Firstly, the insurer cannot investigate the claim by speaking to the driver. Now, this is potentially significant in relation to the thousands of small claims where there are no independent witnesses and the police are not involved. Now, it's true, as Mr. Williams submitted to the Court of Appeal and they accepted, that this issue will arise also in relation to identified drivers who disappear. But of course, if the claim is substantial, then it may be possible, if expensive, to find that person. This will never be possible with an unidentified driver. If this appeal fails, then insurers will have a new class of unidentified people in respect of whom they will have to pay compensation with no prospect of being able to investigate the claim or obtain redress under Section 1518. Can I move on to the issue of service? As I've indicated, it's a fundamental feature of our case that when deciding whether to allow a claimant to sue an unnamed defendant, it is important to determine whether it's going to be possible to serve him or her. And my lord, my lady, we say that that is an exercise that should be performed at that stage, not at some later stage. One doesn't say, can the claimant sue the unnamed defendant? And then, yes, how are we going to serve him? The question is, should any discretion be exercised in the claimant's favour at all, if it will never be possible to serve the defendant? And my lords, my lady, can I show you some of the aspects of the CPR that we say bear on this, and happily these do at least appear in the bundles. Firstly, can I ask you to look at the MIB supplementary bundle. In MS 27, which is in tab 44, this is the glossary which appears at the back of the White Book. And on page 27, you will see that about service, it says this: steps required, meaning steps required by rules of court to bring documents used in court proceedings to a person's attention. So service is bringing the documents to the attention of the person. Next, CPR 615, and that's in the first authorities volume, tab 4. MS 985. And this is service of claim form by an alternative method or at an alternative place, where it appears to the court that there is a good reason, and underline those words, to authorise service by a method or at a place not otherwise permitted by this part, the court may make an order permitting service by an alternative method or at an alternative place. And then on an application under this rule, the court may order that steps already taken to bring the claim form to the attention of the defendant by an alternative method or at an alternative place is good service. An application order under this rule must be supported by evidence and may be made without notice. There is a practice direction that goes with that rule, and you'll find that in the MIB supplementary bundle at MS 25, which is in tab 43. This is the practice direction 6APD9, where an application for an order under Rule 615 is made before the document is served, and that is our situation, the application must be supported by evidence stating the reason why an order is sought, what alternative method or place is proposed, and this is the critical part for our purposes, why the applicant believes that the document is likely to reach the person to be served by the method or at the place proposed. And my lords, my lady, if the claimant cannot satisfy subclause 3, namely that he or she believes that the document is likely to reach the person to be served by the method or at the place proposed, then it's unlikely that he or she will get an order. And in the situation that we're contemplating, nobody would ever be able to produce a witness statement that said that the defendant could be served in that way. And critically, that requirement could not be satisfied by alternative service on the insurer. That would never bring the proceedings, the document, to the attention of the tortfeasor, and he's the defendant. Now, my lord, Mr. Williams relied, and in the Court of Appeal, as you know, I accepted, a settled procedure for allowing alternative service on an insurer. And in support of that contention, he drew the Court of Appeal's attention, and this is paragraph 44 of the judgment of Lady Justice Gloucester at CV2 MS 433, to the cases of Murphy and Asbridge and Gertner and Circuit. As I indicated earlier, I agreed in the Court of Appeal, and I agree now, that insurers do accept service on behalf of defendants who are proving difficult to find. But if the insurer does accept service in that way, that is not alternative service on a defendant within the meaning of the rules, because it's not bringing proceedings to the defendant's attention. And unless the insurer has specific authority to accept service on behalf of the defendant, which he will not usually have in a Section 151 case, and he certainly won't have if the defendant is untraced, then that is not proper service at all. It's effectively an artificial device to enable the claimant and the insurer to get on with the action. In circumstances where the insurer may have decided it simply isn't worth requiring the claimant to spend money to find some acceptable way of alternative service in the case of the identified but disappeared driver. My learned friend's reliance upon Murphy and Ashridge and Gertner and Circuit is misplaced with respect, because in neither of those cases was the issue of substituted or alternative service a central issue. And in both cases, the observations of the Court of Appeal were obiter. I can make this point good quite quickly, I hope, by asking you to look at Clark and Vidal, which is in Authorities Volume 1 at tab 20.
I don't think so. I think it's 21.
I beg your pardon, my Lord, 21. In the head note at the bottom of 1218, we see what the original position was on substituted service under RSC Order 65 Rule 4, if in the case of any document which by virtue of any provision of these rules is required to be served personally on any person, it appears that the court is impractical for any reason to serve that document personally on that person, the court may make an order for substituted service of that document. Substituted service of a document in relation to which an order is made under this rule is effected by taking such steps as the court may direct to bring the document to the notice of the person to be served. Now, if we go into the judgment of Lord Justice Stevenson, starting first of all at page 1225, letter C, he refers to what Lord Justice Goddard said in Murphy and Ashbridge, and the quotation is at F. Possibly, I only throw this out in case of any difficulty hereafter, in an order for substituted service in these cases, it may be a proper thing to order substituted service on a defendant by serving his insurers. Lord Justice Stevenson then goes on to comment that that was in effect a throwaway remark, and then he looks at Gertner and Circuit, which was a case in which the central issue was whether or not MIB were entitled to be joined to an action in circumstances where otherwise the matter would go undefended. And Lord Justice Stevenson quotes from Lord Denning in these terms at 1226 F and G. Once they, the Bureau, added as defendants, they would be in a position to urge that the order for substituted service was not properly made and should be set aside. It seems to me not to have been properly made. The affidavit in support was insufficient to warrant the order, for the simple reason that it did not show that the writ was likely to reach the defendant nor come to his knowledge. All that it showed was that if the writ was sent to the Royal Insurance Company, it would reach the MIB, but the motor insurers' bureaus were not defendants at that time, so that would not suffice. It would be different if the defendant was insured with the Royal Insurance Company, that was not suggested. In my opinion, therefore, the order for substituted service made could be set aside if it would serve any useful purpose. If there's any possibility of tracing the defendant in Canada, substituted service should be ordered by advertisement and so forth. And then, if I can ask you to read what he says from Lord Justice Diplock at K&L, which is much to the same effect. Now, the important point about Murphy and Ashbridge and Gertner and Circuit, and indeed Clark and Vidal, we pick up on the next page at 1227, namely the decision of Porter and Freudenberg. Bearing those matters in mind, this is at J, the first thing that strikes one about the judgment of Lord Denning is that he's declaring that the affidavit in support of the application for the substituted service was inadequate to warrant the order, for the simple reason that it did not show that the writ was likely to reach the defendant nor come to his knowledge. Lord Denning was there reaffirming and following the Porter and Freudenberg principle of all substituted service, which indeed is plain from the wording of the rule. It's a substitute for personal service, and the object of it is to bring the important document served, in this case, the writ to the notice of the defendant, so that he may defend the action if he wishes. And then can I invite you, your lordships, my lady, to read Lord Justice Stevenson on the next page between letters G and L. Just to remind your lordships, my lady, Clark and Vidal was a case in which the rider of a motorcycle was seriously injured, but the defendant gave a false name at the scene and couldn't be identified. The claimant commenced proceedings and sought substituted service. They had a name, but it was a false name. They commenced proceedings against Mr. Vidal and sought substituted service on MIB so that they could proceed to judgment and obtain compensation under the uninsured drivers agreement. MIB objected on the basis that since the defendant was unidentified, this was an untraced driver's claim, not an uninsured driver's claim. And that is why what Lord Justice Stevenson says what he does at the bottom of page 1228. But the point is that in Murfitt, Gertner and Clark and Vidal, all three courts took the view that substituted service could not be effected on an insurer properly because that would not bring the proceedings to the attention of the defendant, and therefore it wasn't proper substituted service. But they then said, in a sort of throwaway line, but it may be possible to do it on an insurer without indicating what the basis of that premise was. And the important point about Clark and Vidal for the purposes of this case is that although Lord Justice Stevenson was prepared to contemplate the possibility of doing that, he refused to do it in the circumstances of that case because MIB objected on the basis it was going under the wrong scheme. In other words, the existence of an alternative remedy and the possibility of prejudice were an important factor to take into account when deciding what to do. And that has, we say, strong echoes of this case. For the sake of completeness, Lord Justice Roskill said very much the same. Now,
well, can I ask you just in relation to Lord Justice Roskill? He says that letter H on page 1230 that the dicta of Lord Justice Goddard in Murfin must be related to the facts of a case in which it would seem that the underwriters could have taken over the defence under the usual clause in the insurance policy and then entered a defence for their insured. Can I just ask, what's the position if there is an insurance policy that the car is being driven by some unidentified person?
well, there would be no contractual right to act on behalf of that unidentified person. The contract, which would otherwise enable the insurer to accept service, is a contract personal to it and whoever was the insured under the policy. It couldn't apply in a case such as ours. The only case with respect that actually assists my learned friend is the case of Abbey National and Frost, and you'll find that in the same authorities bundle at tab 12, MS 1046. This was a claim for professional negligence against a solicitor whose name was known but who had disappeared abroad. The claimant had obtained an order for substituted service on the Solicitor's Indemnity Fund, which they sought to set aside. And the case contained a detailed analysis of Order 65, Rule 4, and a rejection of the decision in Porter and Freudenberg that substituted service will only be permitted where the method chosen is likely to bring the proceedings to the attention of the defendant. And we find that in the judgment of Lord Justice North at page 1050. Perhaps the most important, could I ask you to look at 1053? He analyses the gestation of the rules which led to Porter and Freudenberg, and then gives his decision at paragraphs F to H on 1053. I ask you to read that. What this three-person Court of Appeal, Clerkenwell was only two people, Court of Appeal, decided was that the requirement in Order 65 Rule 4 that substitute in subparagraph 3 in relation to is effected by taking such steps as the court may direct to bring the document to the notice of the person to be served was not actually a necessary requirement under the older rules, and that what one should read into it, such steps, if any, as the court may direct to bring the document to the notice of the person to be served. Now, my lords, my lady, I make no comment as to whether or not that's necessarily right. That's what the Court of Appeal decided.
Doesn't look right, does it?
Well, you said it, Lord Sumption, not me. I say no more. Suffice it to say that it no doubt had occurred to the Court of Appeal that if they didn't do something like that, then this claimant was going to go without any compensation, because he wouldn't otherwise be able to make a claim, because he wouldn't get substituted service on the Solicitor's Indemnity Fund.
Lord Justice Norris also makes it clear at the top of 1055, 8b, that the solicitor, that the fund could take over the conduct of the defence.
Yes, and I don't think anybody disputes the fact that if it is proper to allow alternative service on somebody other than the defendant, because, for example, they have a financial interest, then that person will be allowed in as a separate defendant to defend the claim.
Well, what he won't be doing, though, is defending it on behalf of the tortfeasor.
No. No, he won't.
The same observation could be made about this case as Lord Justice Roskell made about Lord Goddard's dictum.
Yes. Yeah. The short point is that these cases only go so far in assisting the respondent's case, and if Abbey, National and Frost is wrong, then they don't support it really at all, other than by obiter dicta. And in any event, they are pre-CPR cases. And in relation to the CPR provisions that I've shown to you, you cannot effect alternative service on a defendant by giving alternative service on an insurer, because that will not bring the proceedings to the notice of the defendant. And that is a reason, a simple reason not to allow this to be done. Finally, my lords, can I ask you to look at the European point?
Could I just, before you're leaving that, on the question of the status of practice directions in this jurisdiction, I said there was authority. I mean, I found there's a case called Beauvale, Secretary of State, the Environment for Communities and Local Government v. Beauvale, 2009, 1 WLR 2274, where Lord Justice Dyson, as he then was, looks in it, examines the status of practice directions and the extent to which they're binding in law and so on.
Yes, thank you, my lord. The respondent's case on the directive, if I've understood it correctly, is as follows. The provisions of Article 18 of the directive require that the claimant has a direct right of action against the insurer. The claimant has no direct right of action against the insurer under Section 151. In those circumstances, it's said, leasing principles should be applied to the CPR to enable her to sue an unnamed defendant, thereby, in effect, giving her the direct right of action against the insurer to which she is entitled under Article 18. And this argument cannot be defeated, so it's said, by the insurer claiming that the claimant will be compensated by MIB because recourse to the guarantee body is a measure of last resort intended only for cases where the vehicle is uninsured or unidentified. Now, our first submission is that the question of whether the claimant can obtain a judgment against an unnamed defendant is a matter of purely national law, which doesn't require any recourse to the Motor Directive. Before we get into any question about whether the claimant has a right under Section 151, which right is or may be affected by directive obligations, she has first to establish liability against the tortfeasor. To do that, she needs a judgment, and that is a matter, whether she can get a judgment, purely of law and procedure under English law. My lords, this is apparent from Farrell and Whitty, which is a CJEU case in the Authorities Bundle 2, at tab 34, 1537. This was a referral from the Irish High Court in relation to an accident where Mrs. Farrell was injured in the back of a van which had no seats. And under Irish law, that meant it was uninsured because insurance for people who were sitting in vehicles without seats was not compulsory. I only refer to it because I wanted to get paragraphs 32 and 33. It should also be pointed out that the obligation to provide insurance cover for passengers is separate from the extent of the compensation to be made available to them in the event of their becoming victims of a road traffic accident. Whereas the former is guaranteed and defined by community legislation, the latter is essentially governed by national law. And then the same point is made in a slightly different way in paragraph 33 over the page. And for your Lordship's note, I'm running out of time, so I can't take you to it. The same point is made by the Advocate General in his opinion in Wilkinson. I'll give you the reference. It's AV2, tab 30, MS 1368.
For a paragraph.
I beg your pardon.
All right, I'll find it.
Paragraph 22, I think.
It's paragraph 22, thank you. So there's no question in this case but that the directive obligation would be fulfilled, provided that the claimant can obtain a judgment, because then the insurer would be obliged to satisfy it under Section 151. But the question of whether the claimant can obtain a judgment is purely a matter of English law. Now, turning to the directives, the respondent, not surprisingly in her case, places great emphasis on the terminology of the directives and the fact that the articles speak consistently of unidentified or uninsured vehicles rather than unidentified or uninsured drivers. On that basis, the respondent contends that it's only if the vehicle is unidentified or uninsured that the guarantee body becomes involved, and that is inapplicable if the vehicle is insured, even if the driver is unidentified. And that distinction is apparent throughout the directive. The directive does speak of uninsured vehicles and unidentified vehicles and uninsured vehicles. But the problem is, and this arises a lot in this field, that the language of the directive is readily understandable in an insurance system where it's the vehicle which is insured, but it's less clear in a system such as ours, where it's people who are insured. And the untraced drivers agreement specifically recognises that, the MIB's agreement, because it speaks of untraced, unidentified persons, not unidentified vehicles. Now, the terms of the untraced drivers agreement were considered by the Court of Justice of the European Union in Evans and the Secretary of State. Mr. Evans was the victim of an untraced vehicle. He sought compensation from MIB, and he was unhappy with the award, so he appealed it. The appeal was unsuccessful, and the arbitrator, because there was an arbitration process under the Untraced Drivers Agreement, it reduced his compensation by 20%. He brought a Frankovich claim against the UK government, contending that it had failed properly to implement the directive. There were 5 questions. Had the UK government properly implemented its obligation to provide a guarantee fund under Article 10 by entering into the agreements with MIB? He said no, but the court said yes. There's nothing wrong with entering into agreements. You don't need legislation. Secondly, does the arbitration procedure under the Untraced Drivers Agreement conflict with the UK government's directive obligations because it doesn't provide any effective judicial control? The court said no, there's nothing wrong with that. Should interest be awarded on payments under that scheme? The court answered yes, and MIB subsequently amended the scheme to provide payment of interest. Should the applicant be entitled to costs of preparing the application? The court answered no, save to the extent necessary to protect an applicant's rights, and that's a matter for the determination of the national court. And finally, should there be Frankovich damages, that's a matter for the national court. What we're concerned with is the observations of the CJU in relation to the treatment of untraced drivers. Can I ask you to look in Evans, that's AV1, tab 33, it's AV2, I beg your pardon, tab 33, MS 1510. These are the preliminary observations of the court at line 22. In contrast to the victims of damage or injuries caused by an identified vehicle, victims injured by an unidentified vehicle. 1510. I'm sorry, my lord.
Where are you?
I'm in
paragraph 22.
Paragraph 22 on page 1510. In contrast to victims of damage or injury caused by an identified vehicle, victims injured by an unidentified vehicle are normally unable to enforce their claims in legal proceedings for compensation because of the impossibility of identifying the person against whom proceedings should be brought. In the case of an insufficiently insured vehicle, even if the victim is able to identify the person against whom legal proceedings should be brought, such proceedings are often liable to be fruitless because the defendant does not have the requisite financial resources to comply with the judgment given against him or even to pay the costs incurred in the proceedings. It's against that background that the first subparagraph of Article 1.4 of the directive provides that each member state is to set up or authorise a body with the task of providing compensation, and that's MIB. So, my lady, we say that in Evans the court was recognising that there may be circumstances where, for one reason or another, you cannot obtain a judgment against an individual tortfeasor, and that it is quite proper in those circumstances for the claim to be dealt with by the guarantee fund, which cuts across the entire notion that it's only in relation to unidentified vehicles or uninsured vehicles that the MIB or guarantee fund would respond. And, my lords, the same point is made by the Advocate General I'll give you the footnote because I'm seriously running out of time. The reference is tab 32, page 1440, paragraph 30, footnote 12. Perhaps I'll just read it. He says, this is, in what follows, I shall refer to untraced vehicles as well as to untraced drivers. The differences in terminology are attributable to the fact that the directives refer to vehicles, whereas the agreements between the MIB and the Secretary of State for Transport make reference to drivers. Again, a recognition that there are differences in the way in which directives will be interpreted by different member states. Can I turn to Article 18? First, for Article 13. My learned friend says that the claimant is entitled to a direct right of action under Article 18 to give effect to her substantive rights under the directive. In order to understand that contention and our answer to it, can I ask you to look first of all at Article 13, which is in the Authorities Volume 1, Tab 10, MS 1034. Can I ask you to read Article 13?
1024, did you say?
1034.
It's actually tab 11.
Okay.
Beg your pardon. No, you only need to read down to letter C.
Oh, I'm not sure I'm looking at the right thing either.
This is exclusion clauses, is it?
Tab 11, exclusion clauses, yes.
Right.
Yeah.
It may be convenient while you've got this open to read Article 18 as well. That's a short article across the page. I will have to come back to it. Article 13 has three ingredients, being things which the member states shall take appropriate measures to avoid. A, exclusions in relation to persons who do not have express or implied authorisation to do so. Well, the UK implemented that in section 1512 of the Road Traffic Act, which together with 1515 requires insurers to pay judgments even if the contract doesn't cover the driver. B, persons who do not hold a licence. The UK implemented that in section 1513. The insurer has to pay the judgment even if the driver wasn't properly licensed. And C, persons who are in breach of the statutory technical requirements. That was implemented, indeed it was already in place, in section 148 of the Road Traffic Act, which renders of no effect contractual provisions relating to age or the condition of the vehicle. Article 18 says that member states shall ensure that there is a direct right of action against the insurance undertaking covering the person responsible against civil liability. Now, covering the person responsible, certainly in terms of English law, means covering the person who is contractually entitled to cover under the policy. And that is what we say Article 18 means. And that is the only direct right of action which a member state is obliged to enforce. And not only is that my submission, but it appears that that's how the UK government understood it, because that's how it implemented the right in the 2002 regulations, which I'm afraid I've got to ask you to look at as well. That's in AV1 tab 5. AV1 tab 5, MS 994. Now, these are the European Community's Rights Against Insurers Regulations 2002. Accident means an accident on a road or other public place in the United Kingdom caused by arising out of the use of an insured vehicle. Insured person over the page means a person insured under a policy of insurance satisfying the conditions. Under subparagraph 3, for the purpose of these regulations, a vehicle is insured if there is in force in relation to the use of that vehicle on a road or other public place in the United Kingdom by the insured person a policy of insurance, and then the direct right of action. Paragraph 2 of this regulation applies where an entitled party has a cause of action against an insured person in tort, or as the case may be, delict, and that cause of action arises out of an accident. Where this paragraph applies, the entitled party may, without prejudice to his right to issue proceedings against the insured person, issue proceedings against the insurer which issued the policy of insurance relating to the insured vehicle, and that insurer shall be directly liable to the entitled party to the extent that he is liable to the insured person, i.e. in contract. So the 2002 regulations have the effect, we say, of implementing Article 18. And the literal construction of Article 18, for which we contend, deprives no victim of compensation. If there's a contractual insurer, then there's a direct right of action against him under the 2002 regulations. If there's no contractual insurer, but an identified driver against whom the victim can obtain a judgment, then the insurer must meet the judgment under Section 151. And if, as in this case, there is nobody against whom a judgment can be obtained, then the victim is compensated by MIB. The victim does not go without compensation in any of these circumstances. And I don't have time to take you to it now, but, my lords, if you have the opportunity, the idea of the interlink between the MIB agreements and the Road Traffic Act in terms of providing compensation for the victims of motorists is not only to be found in Sahin, but as you will have seen in Sahin, is also explained and developed in the judgment of Lord Justice Ward in Bristol, Alliance and Williams. I'm afraid time means I don't have time to take you to that. Yesterday, my learned friend Mr. Williams sent us copies of two further cases, Candlin and Delaney. I'm not objecting to the fact that they were late, but I'm not entirely sure how he will put his argument on them. For the present, I make the following points. Candlin, we say, doesn't add to the debate. It doesn't deal with the issue raised in evidence about the equivalence of untraced drivers and untraced vehicles. Delaney is an English case where the passenger in a vehicle was injured. The insurers avoided the policy and obtained a declaration under Section 152, which meant that the vehicle was uninsured and the claim was directed to MIB. Found in the car at the time of the crash was 240 milligrams of cannabis, and the trial judge found that the claimant and the driver were engaged in the illegal supply of drugs. There was an ex turpi argument. I needn't trouble you with that. The MIB agreement contains various exclusions, one of which is that they will not be obliged to compensate if the vehicle being used at the time of the accident is being used in the course or furtherance of a crime, and the Court of Appeal found against the claimant on that basis. He then started a Frankovich action against the government, saying in terms that provision is unlawful. in the terms of the directive, because it's not an exclusion which the directive permits. And he succeeded on that in front of Mr. Justice Jay and the Court of Appeal. But can I ask you, for our purposes, simply to look at a short passage in the judgment of Mr. Justice Jay in the what I call the Respondent's Supplementary Bundle, but I'm not sure if the documents have reached the court yet.
Yes, they have.
Thank you.
Tab 51,
It's
I think, isn't it?
tab 51, and the part of it that I'd ask you to look at is paragraph 36 in the judgment of Mr. Justice Jay. He has, at paragraphs 35 and following, been considering the opinion of the Advocate General Lentz in the Ruiz Benaldez case. And at paragraph 39, he comments on it. He said, the third point I derive from these paragraphs of Advocate General Lentz's opinion is that although the scheme of Directive 84.5 is such that the insurer, if it exists, and not the national body, should pay compensation, provided that the system as a whole ensures complete protection for victims, there may be no objection in principle to the national body having an enhanced role. This is exactly the position which obtains in this jurisdiction on account of Section 1522 of the 1988 Act.
Miss 36.
I'm sorry, my Lord.
Tran, I'm with you now.
Paragraph 39.
Yep.
However, the logical corollary, the national body, of course, in this case is the MIB. However, the logical corollary must evidently be this, that the national body, here the MIB, must pay compensation in circumstances where the insurer, for whatever reasons, which must include the avoiding of the insurance policy for misrepresentation or non-disclosure by the insured, owes no liability in respect of the victim's claim. Were the position otherwise, the victim would be left without a remedy, even in circumstances where there was no blameworthy conduct on his part. So, my Lords, what we get from this, we say, is that Mr. Justice Jay, as in other cases, Evans, was recognising that there is some flexibility in the interaction between the insurer and the guarantee fund, in this case the MIB. My Lords, finally, can I just say one or two words on the Mar-leasing principle? I'll have to deal with this in a minute or two.
Well, it's
The whole
pretty
of
well
this,
covered in your case.
it's covered in our case. The short point we make is this. Article 18 cannot find its way by any route into either the legislation or the CPR for this reason. One cannot mar leasing Section 151 so as to give the claimant a direct right of action against the insurer, because Section 151 says in clear terms that the liability of the insurer only arises when the claimant has a judgment against the tortfeasor. So it would go against the grain of 151 to mar leasing it to achieve what the claimant wants. Exactly the same applies to the 2002 regulations. They are incapable of mar leasing for the same reason. What the claimant then does is to say, well, we'll use the CPR to bridge the gap between the victim and the insurer by giving her the Article 18 right which she claims to have, by using the CPR to enable her to sue an unnamed driver. Lord, there is one large piece of grit in that argument. Even if it were correct, that is not to give the claimant a direct right of action against the insurer. It is to give the claimant a direct right of action against the tortfeasor, which is different. So, with respect, she cannot achieve a direct right of action under Article 18, assuming she's entitled to it, by that route. At that point, I think I'm obliged to sit down.
Very much.
The Lords, on behalf of the Bureau, the Lord and the Lady on behalf of the Bureau, I intend to deal firstly with the unidentified defendant point. I'll put it that way in general terms at the moment. Secondly, to deal with the untraced drivers agreement and its purpose, the need for it, and whether it offers an inferior remedy. And finally, I'll deal with the encouragement of fraud. We support the appellant's appeal, and to the extent that there is a minor difference of approach in relation to the unidentified defendant point, which I'll come on to in a moment, we adopt the appellant's submissions. I don't intend to duplicate those submissions, obviously, and given the length of time that I'm permitted, if during the course of my oral submissions I omit anything that is referred to in the written submissions, I'd be grateful if the court will nonetheless take them into account.
Of course.
The reason, perhaps it's helpful to start, to explain the reason why the Bureau has sought permission to intervene. The Bureau's concern is twofold, really. First, the integrity and the continued operation of the untraced drivers agreement, which is described by Mr. Ryman Tubb in his witness statement effectively as being invaluable and an integral part to the system of compensation of victims of motorists. But secondly, the implications that the Court of Appeal judgment may have in relation to the encouragement of fraud. So far as the untraced drivers agreement is concerned, the Bureau regards itself as being ideally placed to assist the court as to the operation of that agreement and the benefits that it produces and the risks that may flow from its restricted use or redundancy. It is the case that each year there are approximately 17,000 applications under the untraced drivers agreement for compensation against victims of untraced drivers. The Bureau's number of claims under the untraced agreement is greater than that under the uninsured drivers agreement. It didn't used to be the case, but that has become the case. So there are more cases dealt with under the untraced agreement than there are under the uninsured agreement. Can I begin by dealing with the unidentified defendant point? The way it was put in the intervener's grounds was that it is not permissible to have a claim for damages alone against an unidentified defendant. Perhaps it is more appropriate to express it this way, that it is not permissible to have a claim for damages alone against an unidentified or unnamed defendant who cannot be served. And if that is the way that I express the principle on behalf of the intervener, one can see that there is therefore very little distinction between Mr. Worthington's stance and mine. The submission I make is supported by the following. The first is there is no direct authority on this point in which a claim in negligence, which is a personal action seeking damages for a single act, a claim in damages in negligence alone has been permitted against a defendant who cannot be served. The closest one comes to it is CMOC, where the defendants are not named, but they were nonetheless served, and an order was made against them. The closest one comes to it, and although this predates the CPR, it's difficult to understand why the principle shouldn't be the same, is that if one goes to the Bloomsbury case, Sir Andrew Morritt's judgment, in the authorities bundle, first authorities bundle, tab 16, and turn on, please, to page 1127. Paragraph 5, he was referring to the Fry and Barnett case, which long predates the CPR. It was a claim where the plaintiff sought to recover the cost, so it's a claim for damages, of certain street works from the relevant frontage. They didn't know the names and issued a writ against the owners of certain land. They then sought permission to amend to cover at the time of completion to clarify it, but the judge refused and the Court of Appeal upheld that decision. I'm not, by reason of restraints of time, going to read the contents of the following paragraphs on page 1128 but for your lordships and my lady's note, it's the, the section from Lord Hanworth, Master of the Rolls, from Lord Justice Atkin and Lord Justice Lawrence at 6 and 7. Just pausing in paragraph 7, Lord Justice Lawrence added, "This is a writ in personam, and in my opinion the writ is not naming the defendants but merely describing them as the owners of adjoining property is bad." That, I suspect, is the conceptual issue that my Lord Sumption identified, and which is troubling and troubled the Bureau when the Court of Appeal judgment was understood. If that is the principle, and there is a good reason for it, the first is that an act in negligence is based upon a discrete single event. It's not based upon a wrong that is going to be repeated, whereas in the injunction cases, clearly the purpose of the proceedings principally is to prevent the repetition of wrong rather than to obtain justice for a wrong that has passed. And if in that case, and in this case, the fact is that this defendant cannot be named, cannot be contacted, there is no means to contact the defendant, and therefore cannot be served. And on that basis, the claim for damages is futile. It will never achieve the purpose of the fundamental direction of a claim for damages in negligence. So here we submit, differently from the appellant, that where the defendant cannot be served because he is unidentified or unnamed, then proceedings are impermissible.
It may be that you know, while you put it just now on the basis that the proceedings would serve no practical purpose, it might be said against you. Well, of course, they serve the practical purpose of creating a judgment which can then be enforced against
Of course.
But, I mean, the more fundamental point might be that service has been regarded as a fundamental aspect of civil proceedings for good so how long? Simply as a matter, essentially as a matter of doing justice, that you allow a defendant an opportunity to defend the proceedings.
Exactly, and therefore that's why I say it's back to fundamental principles, which cannot have been supplanted by the CPR. The CPR provides a new procedural code, but it doesn't supplant the fundamental principle that you cannot proceed, in my submission, against someone you cannot serve and therefore enforce against, because the purpose of the claim in damages is to obtain a money judgment which you can then enforce. And neither of those steps is possible. I have referred in the written case to the authorities of Jamil and Sullivan. Again, just for your lordship's note, that's page 5 of the written submissions, which I submit our authority for the proposition that futile proceedings are an abuse of the process of the court. And we'd also submit that if one pauses and reflects upon a parallel case, suppose this was a claim by a claimant who had been attacked in an alley at night by an assailant who makes off and then seeks to sue that person, there being no evidence as to who it was, no fingerprints, no weapon, etc., no witnesses, is it realistic to suppose that in those circumstances the court would permit that action, even if the proceedings could be issued, to proceed, because there would be no prospect whatsoever that the assailant would ever be identified and a judgment entered against him. The protection, of course, for a claimant in this situation, and in the assault case as well, is afforded by the Limitation Act. And again, we've referred in the written case to the provisions of sections 11 and 14 of the 1980 Limitation Act, which you find in the authorities bundle behind tab 1 at page 891. Again, the reasoning here and the legislative provisions fit, in my submission, with the need for service upon someone against whom you can enforce. So, looking at page 891, the starting point is section 11, which is at page 891. It's a special time limit because ordinarily in the claim for damages for personal injury, it's 3 years from the date of the accrual of the cause of action. But the combined effect of Section 11 on 891 and Section 14 on 895 is that the commencement of that 3-year period doesn't begin until, looking at the foot of page 895, the claimant first has knowledge of the identity of the defendant. So to take my example of the assault case, that claimant is not without a remedy because time begins to run in the event that he later, say 10 years later, because of another case that's come to the police attention or whatever, he's then able to say, well, now I can identify the assailant. He's protected under Section 14. But it's important to understand in my submission that Section 14 and Section 11 are a protection, whereas the consequence of the Court of Appeal's judgment in this case is to give an entitlement to proceed at any stage, irrespective of whether identity is ever arrived at. And that, in my submission, is to misunderstand and to render absurd the provisions of Sections 11 and 14, because in effect it would mean that limitation never begins to run. That can't have been the intention of those provisions. Can I pass on from the unidentified defendant? If indeed it is a discretion, can I merely observe this, that in our submission, both pursuant to the overriding objective and as a matter of discretion generally, the court must have consideration not merely to the just interests of the parties themselves, but the wider implications of the public at large and the administration of justice. And in this case, the focus upon the efficacy or the real interest to the claimant ignores the effects of undermining the untraced driver's agreement. So my submission is that the exercise of the discretion, if indeed that is the way it is to be approached, isn't taken wide enough by the Court of Appeal in this case. Can I move on to the untraced driver's agreement? And just so that I can put it in context, Mr. Ryman Tubbs' evidence in Core Volume 1, behind tab 3, at page 89, paragraph Roman 2. It explains there why the untraced agreement and the safeguards it provides the Bureau with are so important. And just to pick 2 sentences, hope not out of context, the second sentence, I cannot emphasise strongly enough the value to MIB and therefore to the industry and the public of the UTDA safeguards in combating fraudulent claims, and which would not be available in respect of post-Cameron claims under the UDA or claims made to insurers. And then a little further down, the ability to obtain a signed statement is a highly important and necessary safeguard, bearing in mind there's no defendant. So that's the context, and that is Mr. Ryman Tubb on behalf of the Bureau saying that it is a highly important safeguard. The reason can be understood when one goes to the 2003 agreement, which is in the authorities volume behind tab 38. This is the 2003 agreement. You also have behind tab 39 the 2017 agreement. But the 2003 agreement was that which applies to the cause of action in this case.
MS number?
I'm sorry, MS 1581.
Thank you. Thank you.
I'm not, because of time constraints, going to take you to the mirror provisions in the untraced agreement of 2017. They are the same, although in broad terms, although they're numbered differently and their wording is somewhat different. But The core is that under clause 4 on page 1584, the agreement applies where it is not possible for the claimant to identify the person who is or appears to be liable, etc. That's 4.1d. So that's the meaning of untraced under the terms of this agreement. Clause 7 on page 1590. This is the imposition on the Bureau of an obligation. So shall, at its own cost, both those phrases critical, take all reasonable steps to investigate the claim. It is under an obligation to investigate fully and at its own cost, and it cannot move that obligation towards the claimant. There is no obligation on the claimant to prove a case. It is an obligation on the Bureau to investigate. In clause 8, 1592, the measure of damages is that would have been awarded to an applicant is general and special damages in England and Wales. So the measure of damages is personal injury damages the same. 1594, contribution towards the costs. And that's clause 10. And clause 11, these are the safeguards that Mr. Ryman-Tubb was referring to. So the applicant must make the application in appropriate form. That's paragraph 1. Paragraph 2, the applicant must provide MIB with written authority to take all such steps as may be reasonably necessary to carry out a proper investigation of the claim. That is access to relevant records, and that is key. Next, 3, must, if reasonably required, provide MIB with a statutory declaration setting out to the best of his knowledge and belief all the facts and circumstances, etc. So those are 2 key safeguards, and they are critical because in an untraced case, by definition, you do not have access to the motorist who is said to have been the perpetrator, the tortfeasor. So that provides the context, and that is why, in my submission, when the courts have come to consider it in Carswell, Roadpiece, and Evans, and again the references are in the written case, the courts have accepted that there is nothing inherently bad or to be faulted in having an inquisitorial system as a means of just compensation to victims of motorists who are untraced. And if one takes a standard type of fraudulent claim, and regrettably, fraud is extremely prevalent. The latest Insurance Fraud Bureau database suggested that the loss of cash for crash accidents alone, which are deliberately staged accidents, so accident is the wrong word, they are manufactured accidents, that exceeds £340 million per annum. So this is a serious problem. But take a lesser example than the fraud ring or the large-scale conspiracy. Suppose there is a claim where, a bogus claim, where a driver runs into the rear of an untraced motorist, an insured but untraced motorist, who stops at a roundabout when he shouldn't have done, deliberately to cause the accident. The driver runs into the back of the car and claims damages for a whiplash. The driver also claims that he was accompanied by 3 other passengers, all of whom also make claims. Now, those ghost passengers are a common means of fraudulent claims being put forward. Under the UTDA, the Bureau has the invaluable ability to seek from each of those claimants an account as to what they were doing at the time, where they were going, what was the purpose of their journey, why were they in that area at all? Do they have any relationship with one another? How did the accident happen? What time did it happen, etc.? All those details are then accessible, but also accessible to each of their medical records, physiotherapy records, A&E admission notes, etc., which then enable the Bureau to reach a decision in relation to credibility, which is lost under the uninsured agreement or under the litigation route, because in the event the claimants make a claim, they are under no obligation to provide the defendant with those pieces of information, because it is assumed that the defendant will be available. And that is absolutely crucial. So, in the absence of the inquisitorial process, there is an encouragement to fraudulent claims in a time when fraudulent claims are prevalent. And regrettably, and the references in the Court of Appeal judgment I'll give you in a moment, regrettably, the majority of the Court of Appeal did not weigh in the discretion and its exercise the need for and benefit of an inquisitorial system. And that is at the heart of the MIB submission. So the references are Lady Justice Gloucester, paragraphs 57 to 59. That's in the Second Authorities Bundle, tab 12, page 438.
Core volume 2, I think, yes.
Yes, did I say that?
Yes.
Sorry, core volume 2, my mistake. Tab 12, 438, and Lord Justice Jones, core volume 2, tab 12, page 446. The Bureau also has a major concern that the principle which permits this procedural innovation cannot be restricted, and it may eat significantly into the viability of the UTDA, even if it doesn't encourage fraudulent claims. And the reason for that is that in the Court of Appeal, Lord Justice Lloyd Jones used the phrase real benefit when describing the reason for the exercise of the discretion. And again, that is in Core Volume 1, tab 12, page 444, paragraph 76. And interestingly, in the case of Farrer, where the entitlement to take the Cameron-type route was approved where the insurer had a Section 152 declaration, it was because there was a real benefit to the claimant. That was the phrase that Master Davidson used. Now, if that is to be the test, if the test is to be, does the claimant have a real benefit in proceeding against an unidentified defendant who cannot be served, then the principle is very difficult to restrict. What's to stop a claimant saying, hand on heart, well, I've already submitted one claim to the Bureau and they refused it against an untraced driver. I therefore have no confidence in the process that the UTDA sets out. Therefore, I want to pursue another route. Or what if there is delay on the Bureau's part in responding to the letters? Or they get facts wrong when they're responding to the letters? One can see a situation in which this will be used as a starting point, and gradually the UTDA will become less viable and less used. So, the UTDA has to be seen in its context. The inferiority of the remedy is something that has been considered in Carswell in particular, in Road Peace and in Evans. It is the same measure of damages. There is no evidence that there has been a problem with awards being lesser than they should have been, of dissatisfaction, of failure to recover costs entitlement that are appropriate. There is simply no evidence that the hypothetical risks that Mr. Williams identifies have actually eventuated. Even in this day of social media activity, 17,700 applicants applied under the scheme in 2017. And one can understand why a genuine claimant might well favour the untraced procedure, because it is efficient, it's less formal, it's swift, and it doesn't involve going to court and using lawyers. And that may be why it's a system that is attractive and as to which there is no evidence that it is failing to meet the expectations of claimants. The reporting times that are required by the agreement are clear and were dealt with in the road piece judgment, authorities bundle, tab 27, page 1329. The absence of subrogated claims is, in my submission, entitlement to subrogated claims is, in my submission, an irrelevance, because the subrogated claim is, by definition, not a loss to the claimant. If it's feared that there is a no-claims discount penalty, so that the no-claims discount may be lost as a result of the claim being made by the claimant, well, as Mr. Ryman Tubb says, the insurers will cover that cost in most cases, but the MIB will also allow a claim to be pursued if the loss can be pursued, if the loss can be proved. There is no benefit, in my submission, in permitting a court adjudication, and the costs shortfall that my learned friend says will arise because of the schedule ought not to arise because of the MIB's obligation to pursue the inquisitorial process. This is not a case where, if the Bureau are exercising their, following their obligation properly under the agreement, where any need for any representation should arise, which is not covered by the costs schedule. But in overall terms, we submit that it is not an inferior remedy. In the short time available, can I just add a couple of words in relation to the encouragement of fraud? It seems to be accepted by the respondent and was accepted by Lord Justice Lloyd Jones in the Court of Appeal that the result of the judgment in the Court of Appeal will be that some claims that are currently pursued under the UTDA will now be litigated. That is the state of affairs as it presently stands, but it fails to recognise that the opportunistic and organised, sophisticated fraudsters will try to find a point of weakness in the system. And the point of weakness in the system that we perceive, and which we fear on behalf of the Bureau, is being able to proceed against an unnamed defendant who cannot be served. And I've touched on this already. The reason is that you do not have, where you are defending such a claim, the tortfeasor who can deny the event, who can explain it or whatever. You are dependent upon, if it is litigated, the claimant being genuine, and you cannot investigate it. And that, in a situation where fraud is prevalent, is in my submission extremely troubling. The points are all made in the written case, but one point that I just want to expand upon in conclusion, because I'm aware of the time now, is the relevance of the portal. The correct title of the portal is the Pre-Action Protocol for Low-Value Personal Injury Claims. Not surprising that it's called the portal then. In 2017, there were over 776,000 claims submitted through the portal. The reference for that is Core Bundle 1, Tab 1, page 18. It is intended as a fast and efficient way of dealing with low-value claims beneath a value of £25,000, and it encourages quick resolution and quick settlement and the recovery of fixed costs. That's why that's its purpose. Now, under the portal, the procedure is that the claimant submits what is called a claim notification form to the insurer. It's accompanied by a medical report. The defendant's response, if it is an insurer, is required within 15 days. If the defendant is the Bureau, the response is required within 30 days. And if the response is not forthcoming, or if it is not an admission but is later seen to be an error in that it should have been an admission, there are cost penalties. And therefore, the encouragement is, under the portal, that you take a decision very quickly if you are a defendant in these proceedings. Settle the claim quickly for fixed cost, then move on. That is the purpose of the portal. Now, of course, if you permit the Cameron-type solution, the Court of Appeal solution, in a portal case, it is, to put it colloquially, an open goal for the claimants. Because it's going to be completely unrealistic for a defendant to be able to respond in 15 days or 30 days to pursue the fraudulent claim, to get the statement, to get the investigation off the ground. It's just not going to be possible. And therefore, not only is fraud encouraged in general terms, the portal is a particular point of vulnerability. I haven't dealt with other consequences of the Court of Appeal judgment, as my learned friend Mr. Worthington said I might do. I've run out of time. I don't propose to do that. They're in the written submissions if you need them.
Yes.
Can I just ask one point? Mr. Your witness, Mr. Ryman Tubb, says at page 85 the MIB is at the heart of the statutory framework.
Yes.
For motor insurance, but he hasn't identified any statutes. So far, we've only seen one reference in the definition of authorised insurer. I'd like to know, not necessarily now, but at some point, whether there are any other statutes.
Shall I deal with that after the short adjournment?
Yes, that's a good idea.
If there's anything else that anybody wants me to clarify as a point of detail, I will do so, but I'm happy to do that at 2 o'clock.
Very well then, the court will adjourn.
Forgive me, my Lord,
Yes.
just before you write, I don't know if you saw out of the corner of your eye, I know my Lord Hodge did, some slightly horrifying looking boxes being brought into court. What we have in them, and I don't know if it assists to hand it up now or deal it with the usher over the short adjournment, we have got various provisions from the CPR as requested and also section 95 of the 1988 Act.
Well, that's
so I
extremely
don't know when
helpful.
it would be convenient to pass that forward.
Yes. Yes, you want to go over this now? Yes, it would be helpful if that were handed up just now.
Good. Thank you. I'm afraid it isn't indexed, but I hope it's sufficiently self-navigable.
Thank you.
Keep this.
It's very useful.
Thank you.
Thank you.
Well, we're very grateful, and not least to those who've done the legwork to produce it. Very well. The court will adjourn now.